All right, let's dive into India's new evidence law, the Bharatiya Sakshya Adhiniyam of 2023. But you know what? We're not going to get bogged down in all the little details. Instead, we're going straight to the heart of it, the one part that's like the backbone for the entire legal system.
So let me ask you something. When you think about any law, what do you think is the most important part? Is it the punishments, the procedures? Well, the answer, it might surprise you. Believe it or not, it's the definitions. Our source material puts it perfectly. They are the backbone of the law of evidence. I know, definitions don't sound super exciting, right? But seriously, without them, the whole legal structure would just crumble. They're the skeleton holding everything else together.
And this backbone? You can find it in one specific place. Section 2, the definition clause of the new act. Now, on the surface, it might just look like a boring glossary of terms. But trust me, it's so much more. It's really the engine room for the entire legal process.
Yeah, you can almost think of Section 2 as the source code for the entire law. It sets up the whole conceptual framework for everything that comes after. I mean, without a super clear understanding of these basic terms, things like relevancy or proof, they'd be all over the place. Just imagine a trial where fact means one thing to the prosecutor and something totally different to the defense. It would be absolute chaos, right?
So why does this matter so much? Well, because these definitions, they're basically the blueprint for justice. They make sure that every single court, every lawyer, every judge is playing by the exact same rules, working from the same playbook. And this blueprint, it has 4 really clear goals. First, it makes sure everyone interprets concepts the same way. Second, it cuts down on any ambiguity that could be exploited. Third, it gives courts the consistent guide to follow. And finally, and this is a big one, it brings the law smack into the 21st century.
Okay, let's break it down to the absolute basics, the 2 fundamental building blocks of any case. What's a fact and what's evidence? Now, they might sound kind of similar, but in the eyes of the law, totally different things.
All right, first up, fact. So what is a fact? The law says it's anything that exists, something you can perceive with your senses, or, and this is pretty interesting, a mental state. You know, like someone's intention or what they believe. That distinction is absolutely crucial.
So you've basically got 2 kinds of facts. You have physical facts, things you can see, hear, or touch, like a car speeding down the road. But then you have mental facts, what's going on inside somebody's head, their intention, their knowledge. And the law says, yep, both of those count as facts.
Okay, so how does a random fact turn into actual evidence in a courtroom? It's like a 3-step journey. First, a fact gets presented. Then, the court acts like a filter, and it asks one key question. Is this fact relevant to the case? If the answer is yes, boom, it gets through. It's officially admitted as evidence.
Now, this is where it gets really interesting. Let's see how these basic ideas are being used today in our modern digital world. Because one of the biggest updates in this new law is how it officially brings technology into the fold, creating a real framework for digital justice. And you can see this right in the definition of evidence itself. So evidence is defined as oral statements from witnesses and documentary evidence, which, and here it is, now explicitly includes electronic records. That last little bit, that's the real game changer.
Think about it. The old law was designed for a world of paper, right? Of parchment. But this new definition completely expands the idea of what a document even is. We're not just talking about paper anymore. We are talking emails, CCTV footage, you name it, all sorts of digital data.
So here's the bottom line. That digital trail that pretty much all of us leave behind, our emails, server logs, social media posts, all of that is now, without a doubt, welcomed into an Indian courtroom as documentary evidence. It's on the same level as a signed paper contract. Okay, so we've got our facts, they've made it through the filter, and they're officially evidence. Now what? How does a judge actually decide if something has been proven? Well, it's not just a gut feeling. There's a very precise standard laid out in the law. The law actually gives the judge 3 very distinct standards to guide their final decision. And this is so important because it takes subjectivity out of the equation. It makes sure that conclusions are based on a solid, objective framework. And here they are, the 3 standards. A fact is considered proved if the court believes it exists or thinks it's highly probable. It's disproved if the court believes it does not exist. And then you've got this really critical 3rd category, not proved. That's for when the evidence is just balanced on a knife's edge. It's not really proved, but it's not disproved either. You see, these 3 seemingly simple definitions, they're incredibly powerful.
They have a direct impact on who has the burden of proof, who has to do the convincing. And of course, they pretty much determine the final outcome of the entire trial.
And that brings us right back to where we started, from defining a simple fact to filtering it into evidence and finally weighing it to see if it's proved. Every single step of a trial depends on the strength and clarity of these definitions in Section 2. They truly are the backbone of the law.
So, that leaves us with one final thought. The law has finally caught up to things like emails and CCTV. But, as we all know, technology never stands still. So the real question is, what's next? With things like AI-generated content becoming more and more common, how is our legal definition of evidence going to have to change all over again?